The Honorable Saslaw's birthday meeting of the General Laws and Technology Committee will convene now. Clerk, call the roll.
Mr. Chair, you have a quorum.
All right. Senator D. Staff, I'll take you first.
Thank you, Mr. Chairman. We have two quick bills. The first one was Senate Bill 873. We have a substitute.
All right. All in favor of adopting the substitute, say aye. All opposed, no. The substitute is before us.
And Mr. Chairman, we've talked about the issue with DPOR before, and if somebody's not found guilty of a crime, then it's basically left on the record. So what we've done is we've done some research and had some assistance, but with the library, we're doing basically a bill directing the Library of Virginia to standardize its various retention schedules for boards that regulate professions and occupations to allow confidential destruction of records related to complaints or files that have been closed due to an incomplete or withdrawn complaint, insufficient evidence, or inapplicable board regulations. So this is pretty much a simple one. And right now, the time periods on this go from 6 months to, I think it's 3 years, if I'm not mistaken. And what we want them to do is standardize this. If they put it to a year, I think everybody's happy. Or if they make it even 6 months, everybody's happy with that. And it really fixes one of the problems we were trying to resolve with this bill.
All right. Are there any questions of the patron? Is there anyone to speak in favor of the bill or in opposition to the bill? It is a Section 1 bill.
It is a Section 1 bill. DPOR is here. I don't believe they'll have a position.
All right.
But I'm sure they're happy to say that they don't have a position.
Enough said. So,
There you go.
all right.
Mr.
All right.
Chair.
We have a motion and a second to
Chair.
report Senate Bill 873. We need to send this up to Finance. So we add that here.
Mr. Chair. Mr. Chair, to your left.
So, all right. So the motion will be to report and refer over to Finance. So, all right. Any further discussion?
Mr. Chair.
Yes.
So this committee's had, over the last couple of years, a considerable amount of consideration of the workload of the Virginia Library Board. As I recall, Senator Suderline provided several bills trying to provide direction in terms of governors' records and other things, and this seems to be adding to that workload and potentially delaying it. Just a little bit concerned about where the direction from the original bill and direction, and now to directing that workload to another organization.
All right. You want to respond, Senator D?
Happy to, Mr. Chairman, Senator McPike. Traditionally, for all of DPOR boards and commissions, the Virginia Library of Virginia, has done the retention records for them. And if you go through the various DPOR-related boards, they're anywhere from 6 months, I believe, to 3 years, the different periodicities of how long they'll keep the information. So what we're trying to get here is to get them to standardize the retention for that. So it should be pretty simple for them to do and determine which, how to come across how to come up with a standardized schedule for the retention of the documents. I don't think this is very onerous. I think this is something they should be able to do pretty simplistically.
Yeah, I mean, this is very different from the amount of time that they have to be able to process everything. So.
That's correct, Mr. Chairman.
All right. Any other discussion or questions?
Mr. Chairman.
Yes.
Just a simple question. The original fiscal impact, that was the original bill. Is that correct?
Absolutely, Mr. Chairman. That is correct. I don't believe there will be a fiscal impact with this, but that's for somebody else to decide. I don't want to speak for another agency.
Right.
Mr. Chairman, anybody here from the Library of Virginia?
Apparently not. All right. Any other further discussion or questions? All right. The motion on the bill is report and re-refer to Finance. Let's vote on the board.
Ayes 8, noes 5.
All right, that is reported.
Mr. Chairman, next we have Senate Bill 1065. And what this one does is the original bill was broader than I had really intended. It's been scaled back to be a study by DGS. I'm sorry, we have a substitute.
Substitute? All right. Thank you. All right, move to substitute. Is there a second? All right. Any further discussion? All in favor of adopting the substitute, say aye. All opposed, no. All right, the substitute is before us.
So, Mr. Chairman, as if I may, the original bill was a little broader than I had intended. It's been scaled back to be a study by DGS or a Title I bill with no fiscal impact to look at the key boxes. The ones discussed in the bill are much like those already required in Virginia by firefighters, but geared toward law enforcement, particularly officers needing for strategic entry points. We have 18,000 of these key boxes installed in Virginia for firefighters, and police only have access to 11 of them. Not 11,000, 11 total. This bill would establish a parallel system of these key boxes on state-owned buildings that are determined to be high risk. The impetus of this measure came from Virginia Beach mass shooting, during which officers were slowed down by security measures in municipal buildings. The independent investigation into the shooting explicitly recommended these key boxes, which can provide a safe, rapid access to high-risk buildings with one master key, saving time and lives. That's because how and where law enforcement officers are entering a building is critical in the time of emergency or distress where you can't access a secure facility. With the amendments proposed, with this substitute, having DGS determine which state-owned buildings need these and how to implement them, I strongly believe that these key boxes will improve public safety, emergency response, and help protect employees of the Commonwealth. We have a letter from the city of Richmond, and I believe we have some folks, one or two folks, to support this measure.
All right. Is there any questions of the patron? All right. Anybody want to speak in favor of the? Oh, you got a question?
Mr. Chairman,
Yes.
this does not require anybody to use them. It's just a structure to find out what might be needed, where they might be needed. Is that correct?
Absolutely, Mr. Chairman.
Thank you.
Senator Ruff.
All right. Those in favor, come forward, speak.
Mr. Chairman, ladies and gentlemen, members of the committee, I'm Bea Gonzalez with Knockbox. We are the emergency access system company founded in 1975. We have current contracts with about 14,500 cities across the United States, and more importantly in Alexandria, Richmond, Virginia Beach, Hampton, Newport News, Manassas, Bristol, as well as Fairfax, Orange County, Albemarle, Stafford, Loudoun, and Culpeper. We're the manufacturer of these boxes, and so we're really looking forward to working with DGS to kind of inform us on what other state buildings, high-risk buildings, could use these kind of security boxes. As you know, as the Senator mentioned, in the Virginia Beach incident and in the investigation, it was shown that a need for this is very important. And so we're hoping to work with DGS moving forward on the bill. Thank you.
All right. Thank you. Anybody else to speak in favor? Anybody in opposition? All right. Motion to report. And this does not have to go to finance, so just to report, we have a motion and a second. Any further discussion? All right, vote on the board.
Mr. Chairman, members of the committee, thank you very much.
Thank you. All right, next is Senator Stanley.
Good afternoon, Mr. Chairman. Mr. Chairman, I believe there's peace in the valley between the stakeholders on Senate Bill 905, and I believe there's a substitute.
We have a substitute for that. All right, motion and a second to adopt the substitute. All in favor say aye. Aye. All opposed, no. The substitute is before us.
Okay, thank you, Mr. Chairman, members of the committee. This deals with those situations where a landlord has rented a unit to a tenant. There are repairs that need to be made, or there are damages that, quite frankly, constitute a fire hazard or serious threat to life, health, or safety of the occupants of the premises. When that occurs, this bill will allow, if the tenant, through no fault of their own, notifies the landlord then has 14 days after receiving such notice to make the repairs. If the landlord does not make those repairs, then the tenant can obtain a third-party licensed contractor or someone that's approved by the landlord to make the repairs. and then to deduct the cost of the repairs that the tenant bears in that repair from the rent that would be then owed to the landlord. This also has a non-prohibition allowing local governments from procuring third parties in these instances. And it also has a limitation on line 53, and there follows on the substitute, where the tenant is not entitled to the remedies under this legislation where the property condition was caused by an act or omission of the tenant, an authorized occupant, a guest or invitee, and the landlord was unable to remedy the property condition because the landlord was denied access to the unit, or the landlord has already remedied the issue that is present. And that's the bill.
All right, any questions of the patron?
Mr.
All
Chairman,
right. Yes.
down here, other way.
Senator Bell.
I've talked to the patron about this, and I offer a friendly amendment, which amendment I think is friendly. On line 26, after the word performed, and I'll give this to the clerk, so long as 2 estimates of the repair cost are obtained. And I'll explain that. Frankly, as a person who's rented and been a landlord before, I mean, these are not good actors if they haven't repaired these kind of things within 14 days. But to make sure that they don't receive a high cost from a friend, a relative, I think it's important to protect that by making sure there's at least 2 estimates. Normally in this kind of thing, 3 would be required. I went down to 2 in the suggested language, so it's not too onerous on the tenant who already has frankly suffered. But I think to protect the landlord and make sure they're not hit with an extraordinarily high bill, then they would do that.
Senator Stanley.
Mr. Chairman, may it please, being that, I very much appreciate Senator Bell's position, and he approached me about this amendment. I really didn't have a problem, but may it please the Virginia Public Law Center, this is their initiative. It is their piece of legislation, which I agreed to not only draft but carry. And I think when they worked out the deal with the other stakeholders to come to this language, what they tried to do, and when you and I talked, I think we were looking at the original unsubstituted, originally filed Senate Bill 905. And that seemed to be very much a reasonable thing under the legislation proposed as it was originally. However, with the changes that were made between the stakeholders, where we have to have a licensed, third-party licensed contractor, I think that takes care of that, because we're not having Uncle Bobby come in and, charge $4,000 to fix a window pane. So I think that covers that, Mr. Chairman. I think also, too, we have other things, other components where the landlord is given reasonable notice. The landlord is given notice by the tenant. There's a reasonable amount of time for that landlord to make those repairs before this would kick in, where the tenant could then procure the third-party contractor and have the repairs done. And finally, there is that limitation, Senator, that it has built into it now, where there is a limitation. If the damage was caused by the tenant and other factors that would limit the liability or the responsibility of the landlord to make the repairs, I think that settles all of that, but I understand where the senator is going with that. Mr. Chairman, I'd leave it to this committee to determine whether that language should be included or not. But I think the substitute covers something, so we're not just having something created by the tenant, and then they go and get Uncle Bobby out there, and Uncle Bobby charges 10 times as much as a regular licensed contractor.
Mr. Chairman.
Senator Bell.
I appreciate your comments, and reading the substitute, I frankly, I still think the amendment is needed. If you're a landlord, and let's say you have an apartment, and one of the faulty items I think falls into this would be a stove, then that tenant could frankly go buy a stove, and you had a $200 stove, their month's rent's $1,000, they could buy a $1,000 stove, and it maybe not match anything else in the apartment, and there's nothing you could do to stop that. So I think in this case, at least having one other estimate to make sure it's fair and reasonable, especially since there were 14 days, and they're going to have to find someone to do the repair, I don't think is unreasonable. So, Mr. Chairman, I would so move that amendment.
Is there a second?
Second.
All right. Has a motion and a second on this. Any discussion within the committee? All right. All in favor, say aye. Aye. All opposed, no. No. The chair is uncertain. Let's vote on the board. All right.
Who's got Evan?
Ayes 4, noes 9.
Ayes 4, noes 9. The amendment is not adopted, so.
Thank you, Mr.
Any
Chair.
other discussion or questions of the patron at this time?
Chairman, Senator Stanley, the issue of who's responsible for what may or may not be a problem, say it's a plumbing issue, and it stopped up, and somebody's been irresponsible dumping stuff down the toilet and it stopped up. How do you determine who's responsible at that point?
Mr. Chairman, may it please, I'd answer the gentleman by saying it is answered in Section A, which also I think answers the Senator's question, Senator Bell's question with regard to a $1,000 purchase of an oven or stove when the $200 stove has failed. Number one, in that scenario, the $1,000 oven would be the property of the landlord, and the deduction would occur from the rent. Here, Mr. Chairman, I'd answer the gentleman by saying that there has to be really a high-level condition. That is, that there exists a material noncompliance that, if not corrected, constitutes a fire hazard or serious threat to the health, safety of the occupants, including a lack of heat, hot or cold water, light, electricity, sewage disposal facilities, and an infestation of rodents. I believe that when my child stops up the toilet, there may be a serious threat to his life or health or safety, but I don't know that it presents one to me so that it would trigger this part of the statute.
All right, any further questions, Senator Rupp? All right, any further questions of the patron? All right, those in.
Mr. Chairman?
Yes.
Looking at line 18, where it says adequate and some of the other issues in the lines before that, again, I know these are the bad actors, and frankly, I think that I agree with the intent of the bill, but if the landlord were to call if the tenant calls the landlord and says, hey, I don't think my toilet's flushing right, and it doesn't meet this adequate language, the landlord that has somebody come out, looks at it, says, I think it's fine, the tenant could still call and bill the landlord. Is that correct?
Mr. Chairman, I'd answer the gentleman by saying no. I think, when we're talking about having adequate sewage disposal facility doesn't dip down to that lower standard. I think these are very high standards in terms of what triggers the notice provision, the right of the landlord to cure, and then when the landlord fails to cure, the tenant having to take it into their own hands. And I guess when you've got the catch-all, which is the serious threat, a fire hazard or serious threat to life, health, or safety of the occupants. And then you have including, but of course it's including but not limited to, which would also be infestation, lack of heat, hot or cold running water, which quite frankly are requirements, like heat and hot water. That's a housing requirement, a very minimum housing requirement that all must have, including adequate sewage disposal facilities. If those are deficient to the point of non-use, there's no electricity, there's no running water, there's no hot water, and the notice is given and the landlord does not fix, well then, in order just to live a normal, decent life, I don't think it's out of the ballpark to allow the tenant then to seek a licensed contractor to remedy that situation, because ultimately, that's what the tenant bargains for in their contract, the very minimum that they bargain for in the contract with the landlord, that the tenancy that they're about to undertake and that dwelling that they will live in will have at least the basic things, will be habitable, will be safe for habitation, and will allow that person to live a dignified life with their family or by themselves.
All right, any further questions or discussion? All right, those in favor, please come forward.
Thank you, Mr. Chairman, members of the committee. Christy Marrow with the Virginia Poverty Law Center. We want to thank Senator Stanley for introducing this legislation. We want to thank all of the stakeholders, the Virginia Association of Realtors, VAMA, and others who worked tirelessly with us to come to this agreement, to this substitute. And I think Senator Stanley explained the bill perfectly. I would point out, however, in response to, in particular, Senator Bell's concern and Senator Ruff's concern, the language in this bill is not new language. We are not forging any new territory with this. It is the same language in the tenant's assertion statute, which is language that's been there for quite a while, and that is the statute that the courts use to determine whether or not a tenant has a right, because of poor conditions, to reduce the rent or to terminate the lease. So it's not a new standard. Courts are very familiar with it. It's simply saying that tenants can now be proactive and can, after a set amount of time given to the landlord to make these repairs, actually make the repairs themselves. And Senator Bell has said it a few times, and he's absolutely right. We are looking to get at the bad actors here, and we think this will do an excellent job of that. So
right.
we ask you to support this.
Thank you. Next.
Mr. Chairman, members of the committee, my name is Brian Gordon. I'm here on behalf of the Virginia Apartment and Management Association, as well as the Apartment and Office Building Association of Metropolitan Washington. We appreciate Senator Stanley working with us on this bill, and we believe that it's been sufficiently tightened up such that responsible housing providers won't be impacted by this. So we would ask for your support.
All right, thank you.
Mr. Chairman, Chip Dix on behalf of the Realtors, and we likewise appreciate Senator Stanley and the stakeholders working on this bill. We had significant concerns with the original bill, but the substitute addresses most of our concerns. Senator Bell, I reference you to line 34 and 35 and 36, which says specifically that if an act is caused by a tenant, either by an affirmative act or an omission, then they have no right to exercise a remedy. And Senator Stanley's correct that we took the standard out of the existing VRLTA for really unlivable situations for the tenant and said under that standard, if that has not been corrected within a 14-day period of time, and again, it's not complete correction. I'd point out on line 22 that the landlord has to take reasonable steps to remedy this offending condition within that time frame. So limited to that serious bucket of types of offenses, it really is getting at the slumlord type of landlord, and we think that professional managers all across the board will not be in this situation, and it is significantly targeted towards those people that don't provide good housing. Thank you.
All right, thank you. Anyone else in favor of the bill? Anyone in opposition? Okay, we got a motion. Is there a second? Yes.
Mr. Chairman, to the patron, I appreciate you working with me on this, and your dogged your dogged answers and pursuit of this bill, and I will not be tethered to my objections. So I hope that everyone will vote for this fine bill.
All right.
You're using the double entendre this session like nobody else.
Any further discussion? All right. Then we have a motion and a second to report. Vote on the board.
That's 15-0.
Ayes 15, no zero. The bill is reported. Senate Bill 906 is next.
Thank you, Mr. Chairman, members of the committee. Senate Bill 906, admittedly, there is not such a matter of kumbaya, as some say, with regard to this bill, but this bill seeks to then take this relationship when it falls apart in protection of the tenant into court.
Is there a substitute for 906?
I believe there is.
Okay. Yeah, please distribute the substitute. Move the substitute. Second. All right. We have a motion and a second to adopt a substitute. All in favor say aye. Aye. All opposed, no. All right. The substitute is adopted. Proceed, Senator Stanley.
As soon as she gives me a copy of it, if you don't mind. Oh, thank you, bud. The general, what we're talking about, this is not even the good landlord, bad landlord issue, or even good tenant, bad tenant. This is about whether a tenant in certain situations can have an access to justice. Right now, as it stands in the Commonwealth of Virginia, when you have a landlord who refuses to make the repairs that are needed for the tenant and especially, again, when it deals with health and safety, like repairing a broken heating system, stairs, pest infestation. The tenant can sue, the landlord can sue his tenant for non-payment of rent, and the tenant cannot raise the poor conditions of the tenancy created by the landlord as a defense. To take this even a step farther, a tenant who's behind on rent can't even file an affirmative action against a landlord who then refuses to make those repairs. Landlords who do not make repairs are allowed to file cases against these tenants for non-payment of rent and other lease violations that may be occurring, and some hold this over the tenants' heads when they try to demand that repairs be made. So what it does is it creates an unequal positioning in terms of contract, because the tenant is suffering from a threat of eviction if they continue to complain about fixing something that, quite frankly, under the contract, they're entitled to. Now, this does not alleviate everything, but it tries to create a defense for the tenant to raise as a defense the landlord's failure to make repairs as to the non-payment of rent if a warrant in debt or a debt new action is raised. Right now, there are 33 states that allow this type of protection for the tenant. 32 of those 33 states have eviction rates that are lower than in the Commonwealth of Virginia. So this strikes at a policy decision, as we have kind of seen in the Housing Commission and other ways, where we're trying to make eviction more of a rarity. This basically gives them that defense. And again, Mr. Chairman, as any court case that I take on or any lawyer takes on in the courts of the Commonwealth of Virginia, this does not give them an out. Of course, they have the burden of proof to demonstrate why the non-payment of rent occurred, or to use it as a defense as to why I'm not giving rent in a contract where I'm not getting what I bargained for. If I bargained for a two-bedroom house with heat and electricity and running water and a good sewage disposal system, and I'm missing the heat and the water, or I don't have the electricity, then should I be paying the full amount? Let the court determine what that deduction should be. And quite frankly, I think by empowering tenants, what we're also allowing by leveling the playing field is that we're not going to have landlords, those bad landlords, playing that game with them, having this and using it as leverage. And quite frankly, then I would assume that by this, that what we're going to see is less litigation and more of the parties to the contract coming together in order to find a resolution that's mutually beneficial. And that is the bill, sir.
All right, any questions of the patron? All right, public comment on this. Start with those in favor of the bill, or the substitute.
Hi, good evening, Mr. Chair, members of the committee. My name is Sarah Palazzolo, and I'm a social worker at VCU Health System. I'm here representing my personal beliefs. My role at VCU Health is to connect patients and families with legal services to address social issues that keep them from staying healthy. For example, in the past year, I met a mother of two whose ground level apartment had flooded in a thunderstorm. After 6 days, her landlord removed the soaked carpeting, but did nothing to treat the floors or the walls. When she started complaining, she was locked out of her apartment and became homeless. I also met a cancer patient living in an efficiency that was so poorly ventilated and so humid that streaks were visible on the walls and water was pooling in the floor. I spoke with a mother of 3 children. All 3 have severe asthma and allergies, living in public housing and battling mold and bed bugs. She decided to withhold rent to get the attention of the housing authority and was immediately placed in eviction proceedings. Honestly, I hear stories like this every week. These kinds of unsafe and, frankly, illegal living conditions wreak havoc on families' health in a number of ways. Directly, by exposing them to toxins that trigger asthma attacks, seizures, and flu-like symptoms, causing missed school days and work hours. These conditions also affect people's mental health. Being forced to accept these conditions reinforces the painful message that our society sends to people at the margins. Their lives, their safety, and their survival is simply not a priority to people in power. Landlords are already required by law to maintain fit and habitable conditions, but this is not the reality for many low-income tenants. Families often take matters into their own hands to protect their health. And at that point, once they've already withheld their rent or made their own repairs, as the senator mentioned earlier, there may not be a legal recourse. There's honestly nothing we can do to help them at that point. This awesome bipartisan proposal, Senate Bill 906, would give these families a legal defense against eviction and create a legal and a financial incentive for landlords to do the right thing. Thank you so much for your commitment to serving all of your constituents and for taking real steps to address the housing crisis in our Commonwealth.
Thank you. Next.
Mr. Chairman, members of the committee, Christy Marrow with the Virginia Poverty Law Center. Again, we want to thank Senator Stanley for introducing this legislation. And I would echo and emphasize everything that the prior speaker said. Our attorneys across the state see these horrible conditions in many, many, many of their eviction cases, and the judges simply cannot consider them. The lease, as Senator Stanley says, is a contract, and this bill would allow tenants to raise the fact that, or evidence showing that landlords have not lived up to their promise under the contract as a defense. This is something that would level the playing field and probably most importantly, eliminate that dynamic that Senator Stanley spoke about, that again, our legal aid attorneys representing tenants see all the time, where tenants are fearful to ask for repairs, basic things like fixing broken steps, getting rid of mold, getting rid of roach and other pest infestations because they are afraid of being evicted. So we ask you to pass this bill to help level the playing field and give tenants more power to ensure that their home can be healthy for themselves and their children. Thank you.
All right. Anyone else to speak in favor? All right. Anyone in opposition?
Nope, there's nobody in opposition. Oh, hey,
Oh, I'm sorry, Senator Stanley. Chip Dix on behalf of the Realtors, and this provision in its predecessor form has been in the Landlord-Tenant Act in Virginia since 1974. And the fundamental part of this is when you look at the substitute on lines 27 and 28, this situation only applies when the landlord has sued the tenant for non-payment of rent, and the tenant shows up in court and says, I haven't paid the rent, and I'm not going to pay the rent, and this bill would say you don't have to pay the rent, and you can argue any maintenance that comes under this category as a defense without putting any money up to have skin in the game. So the law, as it's been since 1974, has been fair, because what it said is if you're going to claim a defense, number one, you have to give the notice to the landlord and give the landlord an opportunity to cure. And the second thing is you have to put the money up so that you show that you're in compliance with the lease, and it's the landlord in non-compliance with the lease under that circumstance. So with all due respect to Senator Stanley and the supporters of this bill, we think this bill needs more work before it goes forward. Thank you.
All right. Next.
Mr. Chairman, members of the committee, Tommy Herbert representing the Virginia Apartment Management Association, and we would just like to associate our comments with those of Mr. Dix and add that we believe that the escrow process is sufficient for tenants.
All right. Anyone else to speak in opposition? All right. Senator Stanley, any closing comments? Keep them brief.
Mr. Chairman, as brief as possible. Again, it's not just any repair that the tenant could come into court and raise as a defense. It again tracks the same language as Senate Bill 905 did, which is the most egregious violations of the contract between the landlord and tenant: fire hazards, threat to life, health, or safety, lack of running water, heat, electricity, the things that we take for granted as a part of the warranty of habitability when we enter into these contracts.
All right. The bill is before you. Senator Evan.
Just briefly of Mr. Dix or the Apartment Association representative, I wanted to know what your remedy would be for a perhaps less sophisticated, maybe doesn't read the lease, maybe the lease was underwater or something. What would you recommend their remedy be when they can't live? It's uninhabitable under this kind of a situation.
Mr. Chairman, I'd say to Senator Evan, the previous bill deals with a situation where you've got one of these circumstances, and again, it's almost like the landlord should be doing something and they're not doing it, right? So in this situation, the fundamental problem we have with this bill is that there's a notice requirement to the landlord, but there's no requirement for the tenant to pay the rent. If the tenant paid the rent into the court escrow account, that we wouldn't have a problem with the provisions of this bill. So that's the gut of it. It seems to me that consensus has not been built on this, and maybe the Virginia Housing Commission is the place to look at it. But the stakeholders have all been working on this bill, and we're prepared to continue to work on it. And we understand what Senator Stanley's trying to do. We just don't think we don't have consensus at this point on what to do with the bill.
All right. Any other questions? Any comments? All right. Does anyone wish to make a motion?
Remember, Mr. Chairman, a young lady called this bill awesome. I just want you to know that. I've never had that before, so I'm really thrilled.
I'm sure.
Never.
So, move to report and a second. Any further discussion on this? All in favor say aye. Oh, we're going to vote on the board, so.
Ayes 9, nays 6.
All right. Ayes 9, nays 6. The bill is reported.
Thank you, Mr. Chairman. Thank you, members of the committee, for your time.
Certainly.
I was told to remind you, Richard has to go to court sometime.
Right. Senator Stewart. I
You
already knew that.
He just asked me, at the appropriate time, did you tell him? I'm like, okay. Richard's.
Thank you, Mr. Chairman, for the courtesy. I do need to run back over to the Courts Committee. We're trying to juggle several different committees. Senate Bill 1088, we heard a little bit about this. Senator Locke was chairing the last meeting, and we heard some about this. There was some objection, so we tried to work it out. I don't think we've worked it out with Senator McPike. I think Senator Bell had a small amendment for it. But just to recap, what the bill does is when these volunteer rescue squads dissolve.
Senator Stewart,
yes, sir.
I think we have a substitute proposed for this.
I moved substitute.
I was adopted at the last meeting. Okay, thank you.
Yes, the substitute was adopted. Yes, Mr. Chairman.
All right.
When these volunteer rescue squads dissolve, all of these rescue squads, everything's bought and done with public money, either through net drives or the county or the city giving them money to buy the equipment. And the equipment's actually owned by the volunteer rescue squad. And so now there's litigation all over the state now as to what's going to happen. And a lot of the rescue squads want to give it to something else, or they want to create a community center, or they want to do something else. But the public gave the money for rescue squad services. And so what my bill says is it has to go back to the county for rescue squad services, life-saving purposes. It can get kind of complicated if they don't do that with the IRS, and we're just trying to figure out a clean way to do this. Senator McPike had an issue. He's afraid that the localities are just going to arbitrarily start dissolving these rescue squads to take their assets. I tried to figure out a way to draft an amendment to deal with that, but I can't come up with it, and Senator McPike's not been able to come up with it. And I don't think counties want to do that anyway, because if the rescue squads will provide the volunteer service, there's no incentive for the county to take it away from them. The whole issue here is we're losing volunteers. We don't have volunteers to provide this anymore, and so the rescue squads can't function, and the county is having to put in paid people to do what volunteers used to do. And it's unfortunate, but it's just where we are. In our society, people no longer have the time to volunteer for rescue squad or even the fire department, like many of us did when we were younger in various areas. And so that's the bill. I didn't know if Senator Bell wanted to offer an amendment or not. He had a suggestion to it.
Mr. Chairman.
Senator Bell.
My suggestion, while this says it would be returned to the city or county in which emergency search agency was located, my amendment, my suggestion was to, or the nearest city or county that provides emergency services to that area. So if a nearby city or county would then service the area that was previously serviced by this volunteer company, then they could get the equipment. The other thing I would mention is we maybe adding a may or something in here, because if, let's say, the equipment is going to cause the city or county to spend money to dispose of it, let's say it's old and not in great shape, they may not want to take it. So another thought I would offer on that.
So I think he was offering to strike the word returned on line 37 and insert offered, and I would move that amendment.
All right, we have a motion and a second.
Can we,
And then after county, he was suggesting that would read to the city or county or nearest locality that provided the EMS service, or no, or nearest locality, I think is the way you would say it right there, in which the Emergency Medical Services Agency was located. So whatever we're dealing with there is his idea, and I would move that amendment as well.
Second.
All right, staff, do you have that amendment?
so,
That makes sense? Or nearest locality after county?
Let me check with-
Does it not make sense? Can you work with that in concept?
Yeah, I can work with that in concept, Mr. Chairman. Sorry.
All right,
He's got the concept, Mr. Chairman.
Mr. Chairman.
all right.
Mr. Chairman.
You want to offer that a motion just in concept with the understanding that nearest locality, that type of thing will be addressed
Yes,
in
Mr.
what staff's put together? Okay, there's a motion and a second.
And a comment on that?
Okay, yes.
I was just thinking that, and I don't know enough about all the localities, but rather than say nearest, just say a locality that served, the area that was using the equipment. Because if you had more than one,
Mr. Chairman.
The concept, I think what Senator
Yeah.
Bell was suggesting is you may have an area, you may have one squad that's serving different areas, and so we don't want to lock it in, and I'm fine with that. That's the idea. Everything was bought and purchased with public money to provide these services. Everything needs to go back to some public entity to keep providing that service is all I'm trying to accomplish.
Senator McPike.
Mr. Chairman, speaking to the proposed line amendment, I think we're actually introducing more complexity by that language. You have protocols associated with it. We have county charters that govern fire and rescue services, and so you're saying or locality. You're now proposing one adopted set of organization to then potentially transfer to an entirely different organization. And furthermore, I remind the body that when we say rescue services, you're also dealing with fire and rescue service because you have combined, so it's just not rescue services as written right here. So there's a number of level of complexities that I think that amendment just added to this issue.
It's, Mr. Chairman, in quick response, this is drawn to the EMS statute, which is rescue squads, as I understand it, not fire, but I could be wrong about that. It's drawn to the rescue squad section.
Staff, could you weigh in on that issue?
Mr. Chairman, yes, this is drawn to the, as Senator Stewart says, this is drawn to the EMS statute and not the volunteer firefighter statute. It was originally drawn to the volunteer firefighter statute, but we changed it in the substitute, so it would no longer affect that class of.
All right, so it is specific to to emergency medical services. Anything further, Senator McPike?
There are organizations who do both and have separate, Mr. Chairman, facilities and equipment. I would advise that it is cross-cutting across both fire and EMS.
All right, well, we do have a motion and a second for an amendment in concept that staff will prepare, and then we'll maybe have a meeting at the desk tomorrow and try to get this finally resolved there, if this amendment's adopted. Is there further discussion or questions of the patron? All right, all in favor of adopting the amendment in concept to be hopefully completed by tomorrow, please say aye.
Aye.
All opposed, no? No. All right, the ayes have it, so that amendment is adopted. Is there anyone who wishes to speak in favor of the bill? Is there anyone who wishes to speak in opposition to the bill?
Mr. Chairman. Mr. Chairman.
Yes, Senator McPike.
If I can speak to the bill, and I've spoken to the patron both last week and this week. I did provide suggested language to deal with the issue. I'm not sure he's been able to put pen to paper, but I think the stronger concept if the amendments were rolled back at this point, were to be to tie the action to a licensure lost by the state of Virginia. So if the Commonwealth fails to license the organizations for 2 years, a period certain, then to me it's clear that the underlying organization is no longer following through on its required duties. That's not in the bill. I would suggest that that would put in a position where you would not have essentially an underlying property taking action. And right now, as I read the bill, this is a property taking. I have grave concerns with this, where you have an organization that is an independent organization, and while they're providing services to the community, so does a VFW. So does many organizations. And so in my locality, they also provide sheltering services. And so under this sort of context, because one nonprofit or 501c3 is now changing services, you're saying the underlying public donations for that woman's shelter or that battered shelter could be taken as a established in now code, a concept to be taken as a public good. And so we start to apply this theory to other places. I think we get really dangerous and it becomes a taking. And so I think there needs to be some stronger language to tie this to the actual operational licensure. And that's really in the code where we draw what we're doing as a functional EMS or fire organization. Otherwise, this bill has some serious issues.
I'll respond briefly. Mr.
Senator
Chairman,
Stewart.
if you look at section, and by the way, this doesn't deal with battered women's shelters or anything else. It's strictly volunteer rescue squads, and it's drawn to that part in the code. And it's not private property. We're not taking away private property. Most of it's the money that the county has given the squad to provide the service. The rest of it is done through net drives where they raise public money for this. But if you look on line 29, section D, which is the existing language in the bill, and I'm not messing with that at all, any emergency medical services agency established pursuant to this section may be dissolved by the county. Local governing body, county, city, or town in which the EMS service agency is located, if they determine that the EMS service has failed for 3 months successively to have or keep in good serviceable condition emergency medical services, et cetera, et cetera. So they are created by the county. They can be dissolved by the county. No locality wants to dissolve these agencies if they're providing the service. They want them to do it. They give them millions of dollars to do this. Unfortunately, what we've seen happen is people are unable to volunteer anymore. And all I'm trying to do is make it a little easier to get this money back to the public benefit like it was all intended, instead of there being 50 court cases across the Commonwealth, which is what's happening now.
All right. Is there?
Mr. Chairman?
Yes, Senator McPike.
To clarify, the section D is in relation to dissolving their service to the county. It is not the overall dissolving. The county does not have the power to dissolve a 501c3 under IRS federal tax code. And so you're mixing concepts in this that are really important that the body needs to understand, that you cannot dissolve an independent entity. You can dissolve the service under the county charters agreement. So many of them set up, and frankly, some of them pre-existed a lot of the organizations and been around for 100, 150 years before a lot of these more complex city and town charters came into existence. And so this is an entirely different concept than I think as the patrons presented.
I can respond if the committee wants, or I can be quiet if the committee wants, whatever you all want.
All right. We have a motion. Is there a second? The motion is to report the bill. Is there further discussion?
Mr. Chair, if I may, I just as a point of clarification for the committee, I understand what the senator from Prince William is concerned about, but for the senator from King George, I think he's trying to resolve a very specific problem so that it doesn't undercut a local EMS and doesn't undercut the community's ability to recover or disgorge funds that might be misappropriated. And I think he's trying to solve a very specific concern. And I think if we carry it over beyond today, it can easily be resolved and we can have a vote at the desk. So I think that probably that's just very simple, and I regret that it's gotten so bogged down.
All right. Any other discussion?
Mr. Chairman, I'll be happy to work further with the patron
I'm afraid that Senator McPike just doesn't like my bill, Mr. Chairman.
Mr. Chairman, just to correct, that is not true. I've offered you a means to do it and solve the issues and resolve the property taking issue. It's your bill.
The issue, Mr. Chairman, is this. If the county dissolves these rescue squads, and many are faced with this right now, these are very good people that have worked hard to provide services for the county, but now they have a 501c3 under an IRS provision, and they are not providing a charitable service like they're supposed to. These folks become personally liable. It's hard to explain that to some of these folks. They start using this money for other purposes, which they think is okay. Under the eyes of the law, it's either embezzlement or misappropriation. It can be a big deal. This is just a clean way that actually helps these folks get out from under this situation, and I think it's the most prudent way to go forward in it.
All right. Any further discussion? All right. Let's vote on the board on whether to report the bill.
I gave you my proxy.
You can vote.
Oh, I can vote? No, it says for a vote.
It's just to carry it to the desk.
Oh, she got it.
She does it.
Yeah, this is to report this
the
with the understanding that the amendment, this is as amended.
Yes, sir.
And it will be the amendment that we will ratify at the desk hopefully tomorrow, so.
Thank you, Mr. Chairman, members of the committee.
Ayes 12, noes 2, abstentions 1.
All right. 12 in favor, 2 opposed, and 1 abstention. So we will deal with that at the desk tomorrow. All right. Senator Favola.
Good afternoon, Mr. Chair and members of the committee. The bill before you is Senate Bill 866, and it has to do with banning discrimination in the workplace on the basis of pregnancy, childbirth, or related medical conditions. And my bill applies to employers with more than 5 employees, but fewer than 15. I understand that Senator Eben also has a bill that's amending the same section of the code, but my language is a little bit more expansive, so it doesn't conflict with Senator Eben's. It sort of enhances it, in my view. So it's a basic non-discrimination bill, and again, related to pregnancy, also includes if a person may become pregnant or has been pregnant. In the bill, we outline a process. If somebody feels she's been discriminated against, there's, of course, an administrative opportunity for addressing that, and then there's also a civil, you can go to court. And
do we have a substitute, Senator Favola, do we have a substitute for this?
We do not, actually,
Okay.
that I'm aware of, unless staff thinks we have a substitute. No, we don't have a substitute. I don't have any line amendments. It's the bill before you.
All right.
We do?
We had a substitute because we had to move to a new section.
Oh, excuse me. But I'm not sure if the staff have that substitute. Okay, all right.
Well,
I apologize. That must have happened while I was in session.
all right. Does anyone want to make a motion to adopt the substitute? All right. Is there a second? Second. All right. Any discussion? All in favor say aye. Aye. All opposed, no. All right. The substitute is before us. Senator Favola, can you give us any changes, identification of changes?
I think it was just a change to the code, but I presented the content of the bill. Staff, did you want to respond? You were.
Mr. Chairman.
Yes.
What the substitute does is move the substance of Senator Favola's bill into a new section so that it doesn't conflict in any way with Senator Evans' bill.
Senator Evans. All right. Senator Vogel.
Mr. Chair, I was just going to inquire of the patron or of council. I'm just looking at this really quickly. It is very similar to the language in Senator Evans' bill. And I'm just curious, what is the distinction? Because I know in Senator Evans' bill it does have very similar language relating to pregnancy, and it looks like it's consistent with the code section. So I'm just curious if she considered rolling it in, because obviously we want it to be consistent. Because I obviously support
ask
the.
Ms. Healy. Yes, and
Obviously
if-
support
if
the
in
spirit of
fact-
the measure and
yes.
support the bill and support
sure.
Senator Evans' bill, but
Sure.
I just don't want it to be unnecessarily confusing. Thank you.
I would want some of this language incorporated, so, because I think it builds on Senator Evans' language. Do you want to respond?
I think one difference, I'm Megan Healy, Chief Workforce Development Advisor for Governor Northam, is the definition of pregnancy, that you may be pregnant or became pregnant. One of the things we hear from women in the workplace, that they get the question, do you want to have kids? And then they might not get promoted. So currently in human rights law, it's about discharge. So this is discharge and discrimination. So that adds that, which Senator Evans' bill does. It just kind of changes that definition for pregnancy, that may be pregnant or has become pregnant.
But we could incorporate.
Yeah, we can incorporate that as a
that in
definition.
Senator Evans'
Yeah.
bill, if that
All
makes it
right,
easier.
Senator Evans, what's the status of your bill?
Well, my bill is engrossed and ready to pass tomorrow.
So we could,
Prefer to pass mine. Is there any reason we couldn't pass this separately?
no reason.
There's no
Yeah.
fundamental, there's not a conflict.
I just didn't want to delay the other one if I
No,
can.
no,
Chairman.
that's,
I just, Mr. Chair, I'm sorry. Go ahead.
Senator Vogel?
Mr. Chair, I just wanted to make certain that I understood what the distinction was, and there isn't a conflict, and I just wanted to be sure, because they're very similar.
All right, Senator Donovan?
Mr. Chairman, two questions for the patron. The first is, why is this not already covered under the laws that exist to protect pregnant women from discrimination, which is clearly, it's illegal to ask somebody in a job interview what their plans are for pregnancy. It's already illegal. So why are we re-legislating this is my first question.
This bill also would deal with once you are employed, and
You're still protected.
and we're
with
getting
pregnancy.
into issues such as may become pregnant or has been pregnant. And so we're sort of expanding that definition.
Mr. President?
Has a protection.
Mr. Chairman?
Senator Donovan?
I would suggest that you are obscuring the definition and setting up the risk of litigation in a lot of instances. The thing that's particularly concerning is on line 30, if the court finds that unlawful discrimination is about to occur, we're going to start having criminal cause or civil cause for something that's about to occur. I think this needs a lot of work, Mr. Chairman, and I'm very concerned about this bill, both because protections are already in place, and number two, this is way out of the scope of where we should be.
So I can answer some of those questions if you don't mind.
Please.
One is about, originally the law was about discharge. The EEOC rules on discrimination is for more than 15 employers, right? So this between 5 and 15 employers is not covered under EEOC laws. And so that's why we have all these other discrimination bills. The language in C and D is exactly the language from Senator Evans' bill about the intent. One of the things, I will give an example for my friends, I'm 40, that are doing any type of treatment to get pregnant, that actually they say their bosses know that they're going through treatments to try to get pregnant, that they can be discriminated against. So we have heard that, oh wait, now you think you're going to have kids, maybe you won't get promoted. And so just one of those pieces we're thinking about as a discrimination and not just discharge.
Mr. Chairman.
Senator Donovan?
If I may, that is the population I deal with on a daily basis. And I think a have heard and hypothetical is a big stretch to start finding it unlawful for something that is about to occur. And I'll wait till you're ready for a motion, Mr. Chairman.
All right. Are there any further questions of the patron? Senator Evans?
In comparing this bill to mine, I believe that this code section, while it's right near it in the code, it's not the exact same code section unless council advises me otherwise. Is it 3904? I'm sorry, I'm standing corrected.
Mr. Chairman, the substitute as adopted would be a new section, so it would not be the same section that is in Senator Evans' bill.
So therefore, it would not override what's in the other.
I view this as complementary to Senator Evans, so if they were both to pass, we'd have a more
All right,
complete
are there any more questions of the patron at this time?
presentation.
Yes, Senator Mason.
So I think Senator Donovan's made a pretty important point here. In D, line 30, if the court or jury finds that all lawful discrimination has occurred or about to occur, or is about to occur.
Court or jury may award to the plaintiff.
I mean, would you be comfortable striking or is about to occur? Because I'm not a lawyer
Yes.
here, but
Yeah.
I don't know how you'd figure that.
If the court or jury finds that unlawful discrimination has occurred, I would be comfortable striking or is about to occur, if that is your amendment. Are you okay with that?
Yeah, I mean, that's the same
I mean,
language,
that's the same-
right, for the cause of action for Senator Evans' bill, so that's why it's about to occur. That could be you're threatened, like, that you won't get a raise because you're gonna have kids, so that discrimination hasn't occurred because you haven't gotten your raise yet.
But the threat has.
The
But the
threat,
threat
so
has.
that's why it's
So,
And could you tell me where in Senator Evans' bill that is?
I can't find it.
Because we can't find it. Mr. Chairman, follow up.
Senator Donovan.
And perhaps Senator Evans can help me with this, but the language that we had in Senator Evans' bill was specifically did not apply to businesses less than 5 employees, and for businesses between 5 and 15 employees, the small businesses that you're addressing,
what I'm
it
addressing.
only addressed firing. Am I correct, Senator Evans?
Senator Evans.
Prejudice for, that if you were fired with prejudice.
mine is different.
Yours is different. Yours has a far greater scope on small business than Evans' bill. This is not the same bill.
No, it isn't. It's
Senator
not.
Evans.
It's the same.
Different and more comprehensive.
You said only firing. Yeah. This is a whole,
All right.
yeah.
Do we have a motion on the language, line amendment or anything?
Move the line amendment.
All right, and the alignment amendment would be to do what?
Remove where it's about to occur.
On line
right.
30.
All right. All right, we have a motion and a second on striking on line 30 or is about to occur. All in favor, please say aye.
Aye.
All opposed? All right, that amendment is adopted. All right, any other questions of the patron at this time? All right, anyone
Mr.
wish
Chairman,
to?
I move to continue this bill so that it can be looked at more closely. There are a lot of consequences for small businesses that this is vastly beyond the scope of anything we've discussed before for a business 5 to 15. And it's
Senator
not
Donovan,
about firing.
we need to take testimony first, and then
Oh, I'm
we'll, and
sorry.
then we'll get to the motion. So, anyone wish to speak in favor of the bill?
We did find it in Senator Evans' bill on line 320.
Is there anyone who wishes to speak in opposition to the bill? All right, the measure is now before the committee. Any discussion or motion?
I move to continue the bill to next year so that we can take a look at it and see what would be in the best interest and vet this idea a little bit more.
All right, okay, there's a motion and a second to carry the bill over. Is there further discussion?
Mr. Chairman, alternate motion, move to report.
A substitute motion to report, is there a second to that? All right. What's that? Yeah, and if it's a report, it would need to go to finance. All right, and we refer to finance. All right, any further discussion? All right, substitute motion is to report and re-refer to finance. Vote on the board.
Ayes 10, noes 5.
Ayes 10, no 5. The bill is reported and re-referred to
Re-referred.
finance.
Thank you. I may not be as fortunate in finance.
All right. Senator Lucas, we're not going to take you quite yet. We're going to do all the gaming bills shortly here, but I think we have only one other patron who's not a member of the committee before you, so. And I've only voted for you for 12, so. Senator Lewis.
Yes, sir, Mr. Chairman. I believe I have two bills in front of you. One of them, Mr. Chairman, I would ask if the committee would entertain carrying over, and that's Senate Bill 777.
777 is, there's a motion to carry over in a second. Any discussion? All in favor, say aye.
Aye.
All opposed, no. All right, 777 will be carried over.
Next one I have, Mr. Chairman, is Senate Bill 321.
Yeah. Oh, okay, we need to vote on that motion on the board. So the motion is to continue for the year to carry the bill over, so opening the roll. Stewart.
Ayes 14-0.
Sorry.
All right.
Will you do Stuart for me?
All right, Mr. Chairman, and then
All
next
right,
one is
the
321.
motion is,
I'm sorry.
to carry over is 15 ayes and no noes, so therefore that will be done.
Thank you. And the next one is 321, Mr. Chairman.
All right, Senate Bill 321.
And Mr. Chairman, there are some line amendments to that. Yeah.
Mr. Chairman,
Yes.
the line amendments at the beginning of line 15 of the introduced bill, strike A. And then the second line amendment of the introduced bill on line 21, strike all of the lines 21 through 29.
And that was in consultation with our Veterans, Department of Veterans Affairs and Secretary Hopkins.
All right, so that amendment has not been adopted yet, is that correct?
That's correct,
Right.
Mr. Chairman.
All right, does anyone wish to make the line amendment presented by the staff? All right, is there a second?
Second.
All right, it's moved and seconded. Any discussion on the line amendment? All in favor of the line amendment, vote by saying aye. Aye. All opposed, no. All right, the line amendment is adopted.
So with that amendment, Mr. Chairman, it's a pretty simple bill in concept, and what it says is any Virginian who received a less than honorable discharge from the military solely based on his sexual orientation, his or her sexual orientation, that can petition our Department of Veterans Affairs to have their status changed so that they will be available for any kind of state or local ordinance considerations because of their military service. Other states have been doing this. Nevada's done it, Rhode Island's done it, New York's done it. There is no real federal process, no federal streamlined process as of yet to achieve that result, and so that's why other states have started to do it on their own.
All right, are there any questions of the patron? All right, is there anyone who wishes to speak in favor of the bill? All right, is there anyone who wishes to speak in opposition to the bill?
Nope, nobody cares.
All right, we have a motion and a second to report. Is there further discussion? All right, we vote on the board then. Oh, and actually, no, this one doesn't need to go to finance, so that's
Okay,
fine.
thank God. Okay.
Yeah.
That's 15-0.
Thank you, Mr. Chairman. Thank the committee.
All right, that bill is reported on a vote of 15 in favor, 0 opposed. All right, Senator Deeds.
I'm kind of in a tough spot because I've got 6 bills over in courts, and I've not only those bills I've got to present, but I've got a bunch of bills to vote on over there.
Right.
I've got over here Senate Bill 1051.
Yes.
And what makes the spot tougher is that Chip Dix had a proposal for amending this. Here's the problem. I've got constituents that want access to historical records, public records that they can't get to. So I put in this bill, and the clerk's problem was ordering any records that have been sealed by a court. Without a court order, you're not really able to access them. So Chip had a proposal to insert a line into one paragraph, and my constituents have another proposal, which I think they've distributed to some of you all, that just winnows this bill down substantially. And I think either one would, you've got that? Okay. So the substitute that they have might address the clerk's problem as well.
All right. All right, the substitute there's a motion. Is there a second to adopt the substitute? All right, moved and seconded. Any discussion on the proposed substitute? All right, all in favor say aye.
And
All opposed, no. All right, the substitute
what
is
the
before us.
substitute does just says that public documents created before January 1, 1901 are in the public domain, and it essentially just includes what was in the original bill, paragraph A of 42.1-91.1. It doesn't address the issue of a sealed document. Yeah. Confirm. Does the court have an issue with this with the sealed files as well? Look, in your view, does that?
Mr. Chairman, Kristen
Certainly.
Wright, Office of the Executive Secretary, Supreme Court. We had seen the proposal by Chip Dix, and we were fine with that because it did allow that a court could issue an order releasing those records. And so I'm not sure if this addresses the sealing, if this would overtake the court sealing of that record.
Then,
And I'm not, yeah.
I would offer another substitute then. Because I'm concerned about the sealed record. If the court has sealed a record, even if it's one that was over 100 years old, and that's what we're talking about. We're talking about records prior to 1901. If the court sealed a record, they probably had a pretty good reason for doing it. And what the clerks have proposed is that if you want records from a sealed file, you just have to file a petition and show the court good cause to get those records. It doesn't say you can't get them, and I think that makes plenty of sense.
All right, staff, can you summarize this proposed substitute? We'll get to that in a minute.
Yeah. So, Mr. Chairman, the proposed substitute would strike the new language in section 42.1-78 and insert of the original bill, the introduced bill, rather, sorry, and insert after court on line 19, period, and then, however, upon a petition filed with the clerk, presumably, a judge may enter an order releasing any record sealed prior to January 1st, 1901. And then it would strike all of the language in the new section 42.1-91.1.
All right, does anybody have any questions of what is incorporated in the proposed substitute from Senator Deeds?
So,
Yes, Senator Donovan.
It would appear that all of like 19 through records on 21 would be stricken and replaced with the amendment that was just offered.
And I think what my constituents who are here, I think they would prefer to keep the language in paragraph A in 42.1-91.1, the proposed language. I think that would solve one of the problems they've got.
Would that not be in conflict with
With
the
the Chip
sealing?
Dix language, I don't know if it would or not.
What proposal would you like to see us consider?
I'd like you to see you consider the Dix language with that one paragraph of the new language. That would make sure they could get copies of documents, but also would make sure that if there's a filed record, they've got to ask the court for permission to get it.
Staff, is that appropriate to have both of those two in this bill?
Mr. Chairman, so from the substitute, we would take the language in the substitute for 42.1-91.1, keep that instead of the language that's in the introduced bill. And then we would add back in the language from the introduced bill, or at least the section 42.1-78, except instead of having the new language from the introduced bill, it would have, however, upon a petition filed with the clerk, a judge may enter an order releasing any records sealed prior to January 1st, 1901.
I think that would do it.
So it would be the language on that you had presented to staff would replace what's in the introduced bill in 42.1-91.1.
That's right, and you would
And then
add
you would retain the language in 42.1-78.
that Mr. Dix proposed, plus we'd strike the new language, and you'd strike the new language.
Yes, so that's my question, Mr. Chairman.
Senator
I think we are striking line 19 after court through line 21 records and replacing it with the amendment that was read to us, now fondly known as the Chip Dix Amendment.
That's right.
Okay, so that is in 42.1-78. All right, and that language would replace what's on lines 19 through 21, I guess, or through most of 21, the new language that was proposed in the introduced bill. And you would retain A or A and B of 42.1-91.1 in the introduced bill.
Just A.
We just say, okay. Is everyone clear on that?
Where's mud?
Hey, he's from Bath County. What can I say? So,
Mr. Chairman, I think I moved the amendment to the substitute.
right.
Awesome.
I'll second the amendment to the substitute.
All right. Yeah. So staff, you understand exactly what we're voting on here. So
Yes, Mr. Chairman.
it's good somebody does. So therefore, that would be the amendment that would be adopted. Is there a motion and a second on that? All right. We are ready to, all in favor of adopting this amendment, please say aye. All opposed, no. Now, is there anyone who wishes to speak in favor or against the bill?
I've got constituents here, and I guess they can speak if they wish to, but I'd ask you to keep it short.
It's going to be 2 minutes, I promise. I've checked it out.
Yeah.
Less than that, please.
That's it. I'm Janet Hunter. I live in Nelson County. Like many Virginians, I have developed an interest in researching my family roots. Researching family history is the second most popular pastime in America, and a 2009 report noted that 9 million internet users describe genealogy as a core passion or hobby. Another analysis applied to Virginia's population estimates that over 500,000 people have a serious interest in family history, and about half of them are active researchers. African Americans make up the fastest growing portion of that number. When I went online to search for records of my ancestors in the Shenandoah Valley, the website showed that the microfilms of those records had been digitized, but they were unavailable to the public online. A bit of digging revealed that the owners of many of the digitized images were not making them available because they feared they needed permission to do so. These documents are already in the public domain, and I'm asking for simple legislation to make clear that the permission is not needed to make them openly available online. The proposed legislation would allow Virginians and residents of other states with roots here to access the records from home. The records are available on microfilm already, which requires film readers that are harder and harder to find, or they are at some distant courthouse. Travel time can be extensive, particularly where records are found in several different counties. Online access would make research far easier. People with limited income would not need to take time from work to travel to courts or libraries, which are mostly open only during working hours. Court clerks would benefit if fewer people came into their offices in search of basic information. In addition, fewer hands on the original records would minimize wear and tear and possible damage to precious 18th and 19th century records. There's another benefit to Virginia by making family history more available at a distance. Persons living in other states are more likely to come to Virginia and spend money if they've been able to trace their roots and know where their families came from. Thank you for your consideration of this bill.
So the second part of that the original bill, the part that was retained in the substitute, accomplishes what she wants. The first part that ensures that you have to get the court's permission to get into a sealed document satisfies the clerk's concern, I think. So,
Anyone else wish to speak in favor of the bill? Anyone in opposition?
Second.
All right. We have a motion and a second to report. Any further discussion? Let's vote on the board.
Excuse me.
Richard.
Oh, shoot. Sorry. Poor Richard.
Ayes 15, no zero.
thank you very much.
Ayes 15, no zero. And staff, could you prepare this so that we can look at it tomorrow when we have the meeting at the desk? So. Okay. There's a request from Senator Peterson on his bill, which is 1061, and he would like it carried over for the year.
So moved.
All right.
Second.
All right, it's been moved and seconded that we carry over 1061 for the year. Any further discussion? All in favor, we have to vote on the board on this.
So sorry.
Ayes 15, no zero.
Ayes 15, no zero. That will be carried over for the year. Senator Marsden.
Thank you, Mr. Chairman. Senate Bill 915. I believe we have a sub.
All right, it's been moved and seconded that we adopt the substitute. Any discussion? All in favor say aye.
Aye.
All opposed, no. The substitute is adopted and is before us. Senator Marsden.
Thank you, Mr. Chairman. Senate Bill 915 before you reduces the requirement for cosmetology licensure hours from 1,500 down to 1,200. That's the same as a paramedic has to go through, 1,200 hours. I'm confident this change will encourage more people to join the profession. They will become licensed and with much less student debt. The bill fits perfectly into Governor Northam's requirement to reduce unneeded regulation by 25%. At 1,000 hours, which was the bill last year, it came out of the Senate unanimously. And we've added a couple things since then. We've added 200 hours back into the bill, and we've also required that every 2 years there's continuing education. 2 requirements, 2 years continuous education on the bill, and there's a delayed enactment on this until November 2020 to make sure that people have a chance to get ready for the changes. Maintaining a stable workforce is extremely important for the Commonwealth to keep a vibrant and growing economy. Ensuring that our licensure requirements are reasonable allows people to enter professions without unnecessary barriers. The current licensure requirement for cosmetologists is very high at 1,500 hours, which is equal to half a year if you go to school full-time or over a year if you go part-time, and with costs of $20,000 to $25,000. These are opportunities for people to start careers, Mr. Chairman. This is an opportunity. This is more than just jobs. So keep in mind the purpose of all the regulations that our agencies or this legislature passes to protect the patient or consumer. In this case, there are several states that currently have a requirement of 1,200 hours, and they show no more or less number of complaints than states with much higher licensure hours. And the way you become a good cosmetologist is not through going to school, it's through practice. And we feel it's been shown definitively that 1,200 hours can get you to the point where you can get out working in the industry and becoming a master at what you do. I'd really like to thank the Ratner companies, headquartered here in Fairfax County, for being here today. They are the owners of Hair Cuttery, the largest privately owned hair cutting company in the United States. Also with us are representatives from Great Clips and Sport Clips. And Mr. Chairman, it's hard for them to fill the chairs in their office with qualified people. It's slowing down the economy. These are folks very often from limited means. This is an opportunity to go to school and start a career. And combined, these companies and their umbrellas, companies have over 300 stores in Virginia and over 6,000 employees, and chances are you have several of these in your district. And this sub has made it easier for a lot of people to get on board with the bill. And as I said, it came out here unanimously last year, and that is the bill. And I have some folks here from the Ratner companies to testify. But
all right, any questions of the patron?
Mr. Chairman.
Yes, Senator McPike.
I thought that this room was filled of people interested in casinos. I was evidently wrong. So I appreciate it, Mr. Marsden.
As you get older, Senator McPike, you will find that hair becomes an increasingly important part of your life.
Senator Marsden, I do have one suggestion for you. This is leap year this year. We're adding a day in February, but not in November. So therefore, the third, in Section 3, it's on line 26, would ensure that this bill would never take effect because it says it shall become effective on November 31.
You caught me. I was trying to sneak that by you, but that is a good catch. So could we do December 1?
Well, December 1 or November 30. So take your pick. So
I like December 1.
All right.
Easy to remember.
There's an amendment proposed to change. Change November 31 to December 1. Is there a second to that motion? All right, all in favor say aye. Aye. All opposed, no. All right, now we'll have those speaking in favor of the bill.
Mr. Chairman, thank you very much. Matt Bentka on behalf of the Ratner Companies. I know you all heard this last year. The bill last year, we had it at 1,000 hours. That passed out of this committee unanimously and the Senate unanimously. I think that with the bill we have right now, we've solved those problems. Just one thing I want to leave you. We're reducing it from 1,500 to 1,200 hours. That is currently the same amount of hours that's required of a paramedic. Just keep that in mind when you're voting. An EMT is 500 hours. Thank you.
All right, next.
Thank you, Senator. Mr. Chairman, members of the committee, thank you for your time this afternoon. I'm Les Mardix. I'm General Counsel for Ratner Companies, and thank you for the introduction of our company, Senator. We're a Virginia company, as the Senator said, but we also have about 900 hair salons in 14 states in the District of Columbia. Various regulations exist across the land. Virginia, of course, is at 1,500 hours, and what we're asking for is to go to 1,200. New York, Vermont, Texas, Massachusetts are all at 1,000 hours. And I would contend that the people that are coming out of schools in those states are proficient and do a good job and work for us in Massachusetts. And we don't have any more incident of complaints or injuries. And what the regulation is really for, and I would hope everyone please keep this in mind, is to protect the health and safety of the public. Any more than that, it's overregulation. We appreciate your time this afternoon. Thank you very much.
All right, thank you. Next.
Mr. Chairman, committee members, thank you. My name is Keith Kostick, and I am the area developer for Sport Clips haircut brand. And we have the licensure, the development licensure for Virginia, D.C., Maryland, and Delaware. In Virginia, Sport Clips has about 47 stores, three under construction at this point as well, and we're roughly about 400 employees, give or take, on a day. Reducing the barrier to entry in the cosmetology profession, it's really not a local issue, and you'll probably hear that. It's not a local issue, it's not a chain issue, nor is it a franchise issue. It's an industry issue. So taking the opportunity to reduce the barrier to entry, I think it will very much deepen the pool of cosmetologists, allowing for a better client experience, and that is absolutely good for everybody. Thank you very much.
Thank you. Next.
Hi, thank you for your time today. My name is Kim Schottler, and I've been in this industry, the cosmetology industry, for 25 years. I love the cosmetology industry. I currently work for Great Clips. Great Clips is the largest salon brand with over 4,500 salons that employ over 40,000 licensed cosmetologists. In Virginia, there are 100 Great Clips salons that employ over 1,000 licensed cosmetologists. Hair is hair is hair is hair. Why does it take hundreds and hundreds and hundreds of more hours in Virginia to go through cosmetology school than it takes in Florida, Pennsylvania, Texas, New York, Massachusetts? Why? 10 states have lowered hours in the past 2 years alone. Respectfully, this shouldn't be about staff salons need or what schools want for hours. What does a student need? It should be about the student. No one can say 1,200 hours can't be done. States have trained in 1,000 hours, 1,200 hours for 96 years effectively. I'm going to share just a few quick facts from a third-party independent study on the cosmetology industry. The source is the AIR report. It's the state's responsibility to ensure minimum safety. Lower hour states receive the same safety and infection control training as the students do in Virginia. Lower hour states pass the licensure exam rate at the same rate as higher hour programs. Graduates of 1,500-hour programs like Virginia earn no more on average than graduates of lower hour programs.
No, I didn't do that.
And states with similar hours does not equal reciprocity. I wish it did, but it doesn't. Just because you have the same hours as a different state, it does not equal reciprocity. Only 2 states in our country, Arizona and Illinois, have complete mobility in the cosmetology industry. Why keep students in school hundreds of hours longer when it's been proven by states for over 90 years it can be done in less? I respectfully urge you to act on this bill. Thank you.
Thank you. Next.
Mr. Chairman, members. My name is Carl Fox, and I'm a licensed stylist for now over 28 years, as well as an instructor by the state of Virginia. I believe that decreasing the hours from 1,500 to 1,200 hours or so would be a win-win for everybody. I mentor a lot of different stylists throughout Henrico County, ACE programs to Louisa, and go by the other schools as well. And I really believe that the win will come for the school because they'll have a low rate of dropout, as well as students who I talk to daily and mentor weekly. They would not be missing school as much. As well, it'll be a win for the stylists, the future stylists, because they can come into the salon and begin to work with other stylists who can mentor them. After which the school actually laid a foundation, we can build upon that foundation to make them better. And it'll be a win for our clients, so that they don't have to spend our Saturday evenings in the salon for 2 and 3 hours because we have short staff. Thank you.
All right, next.
Good evening, Mr. Chairman, and everyone on the committee. As someone who worked closely with the newly graduates from the beauty...
Give us your name, please.
Oh, I'm sorry. I'm Constance Woodson. I'm also a leader at the haircuttery.
Sure.
And as someone who worked closely with newly graduates from the beauty schools and cosmetology programs, and a licensed cosmetologist also, we hire a lot of individuals, and I get to see and hear firsthand their concerns, and definitely reducing those hours so that they can actually get into the salons, because in the schools they're only getting the basics. So in the salons they're actually getting the actual majority of their experience. So again, reducing those hours is definitely necessary. Thank you, sir.
Thank you. Next.
Hello, I'm Tracy Rosser. I am also with Ratner Company. I'm a district leader, licensed for 31 years, and I think lessening the hours to 1,200 would be greatly appreciated, especially for our single parents that are actually taking these courses so they can get out and make a living for their families. Thank you.
Thank you. Next.
Good evening. My name is Jamie Graham. I am
a stylist at the Ratner Company, and the pay that we it's like over $28,000 that we have to pay when it comes to going for training in school. And I feel like when the time is reduced to only 1,200 hours, they can come into our company and get trained, and they're able to do hands-on and experience the customer service that they can provide for them.
All right, thank you very much. Next.
Hello, I'm Frederick Francois from Hair Cuttery, of course, and I am a salon leader, and I think 1,200 hours is plenty for the students to come on out and just start getting the guest experience and doing hair. Thank you.
All right, anyone else?
You ready for opposition?
Oh, all right. I was just waiting to see if I thought you were in favor. Is anyone else speak in favor? Then those opposed, so.
Mr. Chairman, members of the committee, Cassie Schroth, McGuire Woods Consulting, on behalf of 4 cosmetology schools from all around the Commonwealth, and we respectfully oppose this bill. I haven't been able to fully review the substitute, but speaking briefly, regardless of the number of hours, we're opposed to a cap in the law. We currently don't have a cap in the law, and we think a cap hinders the board's ability to create a licensure program that reflects adequate training to reflect public safety. On the delayed enactment, if we went to the board to review training requirements, well, they've already created a committee on training that's doing that right now. We would ask that you would let them finish their work on the timetable that they need. And finally, while continuing ed is never a bad thing, we think that licensees want to have the full spectrum of training in school, not after licensure. And I have several folks here to speak on the bill briefly.
All right, thank you.
Hi, my name is Doug Worrell. I'm from Virginia Beach. As a 30-year member of the salon industry, I've been a distributor salon consultant, and I think this bill would be harmful because the part of the curriculum that it would cut out from school is the clinic floor time that students get to work on actual guests and get to work with consulting with a guest and looking at hair, actual heads instead of mannequins, and being able to see safety issues like head lesions or lice or skin cancer. Those actual things, they would have to wait until they got into the salon to experience those. So I think it would be detrimental for that. And in all my years calling on salons, I never heard a salon owner or manager say, my new stylist has too much training. I think lowering training or lessening education is never a good thing. Thank you.
All right, thank you. Next.
Good evening. My name is Bridget Craighead, and I'm from Rocky Mount, Virginia, and I oppose this bill. I am a single mom, and I am currently a cosmetology student at Paul Mitchell, the School of Roanoke. I currently have 1,100 hours, and speaking from my experience, I do not feel that I will be ready to enter the workforce and be successful. Also, the program lasts less than a year, which is a short commitment for a lifelong career. If it was up to me, I would go to school happily for 2,000 hours more. And I'm positive that the future professionals that I work with will agree with me. I would ask you to oppose this bill. Thank you.
Thank you. Next.
Hi, I'm Cody Mims. I'm a teacher at Paul Mitchell, the School, Arlington in Texas. So our legislator last year did pass a bill for a cap of 1,000 hours. And the board and the schools are having a struggle trying to implement the gap in that. So we're currently trying to figure out, what do we cut out of the curriculum? So if we're taking hours down, then that means less education. So where is that coming from? Does everything get cut down? Because that means sanitation is going to be cut down. Do we give them less experience on the clinic floor? So that's what we're currently struggling with. So without answers to that yet, it was passed 8 months ago, and we still don't have an approved curriculum from our boards because they were not in favor of this either. In addition to that, 16 years ago, I went to a program in high school where it was lessened hours. And so I went and took my test and held my license in my hand, and I had never cut or colored anyone's hair yet. But I had my license saying that I could go work in the salon. I would hope that Virginia would not follow something that's not working in a different state. Thank you.
Thank you. Next.
Hi, my name is Elizabeth Mead, and I'm an educator from Paul Mitchell School, Roanoke, and I oppose this bill. So because of our current hour requirements, we attract students from across state lines. So we're bringing other students into the Virginia area because of our hour mark. I'm actually a former resident of West Virginia, Arizona, and now a resident of Virginia, and I have 2,100 hours. And because of my hour mark, I have been able to move around, and I have been able to stay with my husband and follow him with his business, and be successful stylist. So I'm successful behind the chair, and I'm also a successful educator. And I've not only been able to stay in this industry, but I've been able to excel and become part of leadership in our school. And I've been able to stay in the industry that I love, and I never want to leave. Also, the idea of adding continuing education is admitting that the students need more education. If we're saying we're going to add continuing education and add a little more hours, then we're actually admitting that they need more education. So why not give them that education while they're in school, and they can get financial aid and support from educators with that? So I think that's all I have. But thank you for your time.
Thank you. Next.
Good evening. My name is Caitlin Mack. I'm the education leader for Paul Mitchell the School, Roanoke. As a licensed educator with over 12 years experience in our industry and with Paul Mitchell Schools, I'm a firm believer that less education is never the answer. Part of our enrollment process at our school is that we do an initial interview with every prospective. On that interview, we ask, where do you see yourself in this industry? Out of 611 prospective students that we've had come through our school, I have never had one single student say, I would like to go work in any of these chain salons. They want to work for themselves, they want to work in a suite, or they want to work in a high-end salon. So we have a petition that was launched by a local Virginia Beach cosmetologist opposing this bill as of 2 o'clock. We had 3,833 signatures. I'm asking you to please oppose this bill.
Thank you. Next.
Good evening. My name is Christina Stocks, and I am an instructor at Rudy and Kelly Academy and Paul Mitchell Partners School in Virginia Beach. I've worked there for 10 years now. If we don't oppose this bill, we'd have to make critical cuts to our educational experience that we're offering at the school, because we would have to cram that education into 1,200 hours. This means that we would not be able to teach them the importance of community involvement. We would have to possibly deduct from the financial literacy that we give them to help them pay back their loans once they graduate school. We would possibly have to cut teaching them how to screen for skin cancer on the scalp. We would also really have to cut back on how much we give back to our community, cutting back on haircuts from the homeless, things that we do to get our students involved into the community. I don't believe that we are doing our students a justice if we're giving them the bare minimum and capping their education at 1,200 hours. I do feel like if we do not oppose this bill, we'll be greatly affecting their education, as well as greatly affecting the future of Virginia cosmetologists.
Thank you. Next.
Mr. Chairman, board members, I'm Rudy Russo. I've been a hairstylist, salon owner, school owner, instructor, and had the privilege to be on the cosmetology board of barbers and cosmetologists for over 60 years. I have been a cosmetologist in Virginia. I'm here to oppose the bill because education is so important to the success of our students, that the whole reason that I started a school was to teach students that were coming into my salons that were not capable at that time. So now with proper education, they can be successful. I strongly disagree with setting a limit on education, and I strongly hope that you will oppose this bill. Thank you.
Thank you. Next.
Chairman, members of the committee, my name is Kristen Kent. I'm the operations leader at Rudy and Kelly Academy. I have the privilege of being his granddaughter. So I come from this as a place of wanting to uphold his legacy and what that means for cosmetologists. Part of me, very passionate about this issue. 1,500 hours is the most common hour requirement among the states. They acted like that was astronomical. It's not. This map shows you that in green, 43 states require 1,500 hours or more. The dark ones are more. I sent all of that to you. You should have received that letter from me. Lowering our standards would harm both cosmetologists and the clients they serve. In fact, the states they mentioned that lowered their hours, the majority of them were to 1,500, not below that. Also, the stylists we graduate at 1,500 hours are better prepared to start immediately behind the chair and therefore have more options when they graduate, such as starting their own business or working in high-end salons instead of chain salons that may not pay as well. Limiting their education means limiting their choices. We are required to track our placement of our graduates. I checked our annual report. Of our placed graduates in the most recent reporting year, 81.8% were placed in independent salons or self-employed. That's 72 people out of the 88. This is actually an increase over the previous year when it was only 74.5. Cosmetology graduates are choosing to go into independent high-end salons over chain salons. Lowering the hour requirement will not change the trend away from chain salon employment. Additionally, in terms of retention, of the 16 graduates who are placed in corporate salons, only 7 are still at the same salon. That's less than half. That's why they need to hire more often. That's why they have a workforce shortage. That workforce shortage is not going to be addressed by lowering the hour requirement and reducing the education of graduates. Also, I don't know where the loan debt information was given to you, but the maximum amount that they can receive in loan money is $16,500. That's not the astronomical 20. That's just a lie. That's wrong. So that might have been some private loan that she took out above and beyond, but that's not true in terms of the Department of Education loans. But what it would do is it would eliminate thousands of dollars in Pell Grant money that our students would be eligible for. That makes it harder for students who are of a lower socioeconomic status to be able to attend school because the schools aren't having any cost reduction by this hour bill. We still have the same rent to pay. We still have all of the same expenses. So it's not going to change the tuition. What it is going to change the ability for students to be able to attend school. Thank you.
Thank you. Next.
Mr. Chairman, members of the committee, Mary Brosvaughn on behalf of DPOR and the Board for Barbers and Cosmetology. The administration opposes this bill fundamentally because a hard cap establishing a limitation on hours prohibits the board from fulfilling its statutory responsibility to establish the minimum competency standards for entering the profession. This does not mean that the board is at all opposed to continuing the discussion about whether 1,500 hours needs to be revisited at another time. In fact, after this bill, or a version of this bill, was introduced last year, the board formed a training committee to have this very discussion and met throughout the interim with stakeholders to talk about whether the hours required and the training modules need to be revisited. When JLARC did its review of the agency and our general regulatory requirements in 2018, cosmetology was not one of the professions recommended as requiring any sort of deregulation or at all being outside the norm. I just point that out. And so during the interim, the board, as part of its training committee, has had this ongoing discussion, does currently feel that 1,500 hours for the full scope of cosmetology, which covers more than just hair care,
also covers waxing, nail care, and skin care, is appropriate, is well within the national scope of practice. But again, the regulatory process is where we believe the delegated authority from the General Assembly is most appropriate to establish training hours. And so that's why the administration opposes this bill. The executive director for the board is here with me to answer any technical questions you have.
All right.
We'd be most concerned that lowering the hours also could jeopardize apprenticeship, which is the alternative path to licensure for folks who cannot afford to go to cosmetology school right now. It allows them to earn a wage while they get their training. And if I may, just one quick point, when comparing with other types of professions like EMTs, I'd point out that when you get your cosmetology license, you're automatically authorized to have some sort of autonomous practice. I mean, you can go and, provided you also have a salon license, practice by yourself. I mean, some folks don't, and then go to a salon or, practice with a mentor, and that's great, but you don't have to. You can go practice by yourself. So you want to make sure that you're very, very well trained. Thank you.
Thank you. All right, are there any questions for the people from DPOR, from the board? All right. Senator Marsden, you want to sum up?
Well, yes, Mr. Chairman, the, DPOR, I think, has 2 cosmetologists on their board of 10. I don't know, how much they are able to, to really, deal with, all of the issues that come up around reducing the hours. This is a national trend that's going down. We're trying to reduce the barriers for people to get into the business. It'd be great if everybody could get, this might be, a high-end school, and maybe a lot of people do get into the higher-end salons, but there's a limit to that. A lot of people are going to have a cosmetology career in a chain, and right now they're having tremendous difficulty trying to entice people into the profession, because of the time and money barriers that are presented. And so this was a bill, I think, whose time has come. Basically the number of hours have been created by schools over the years. We think they can be adjusted. As remember, we did 1,000 last year out of this committee. We're making it 1,200 with continuing education, and I think it's a bill that we need to pass and to get more people out there working and make this available to more Virginians, and that is the bill.
Mr. Chairman.
Yes, Senator Bell.
I believe we did the amendment before on line 26 with the date. I would bring to your attention it's also incorrect on line 24, and I think we need to make an amendment to change that as well. Second.
All right. Moved and seconded to change November 31 to December 1 on line 24 as well as on line 26. All in favor say aye. Aye. All opposed, no. That amendment's adopted as well. All right, the bill is now before the committee. Is there any discussion or motion on the proposal?
I move to report.
All right, it's been moved to report. Is there a second?
I'm seconding.
All right, second. All right, any discussion on this issue? All right, then we will vote on the board.
Ayes 8, no 7.
Squeaked up. Thank you, Mr. Chairman, members of the committee. We'll see you on the floor.
All right, thank you. The bill is reported on a vote of 8 in favor, 7 opposed. It will now go to the floor in the Senate. All right, Senator McPike, you want to present the
all right, Mr. Chairman, I think we just dealt with the most controversial thing of the evening just before this. But the General Laws Subcommittee report on gaming. The subcommittee met on February 4th, and we took up the remaining 8 bills dealing with gaming. The first batch will take, I first wanted to take a moment to thank JLARC staff. They provided us with a brief report and overview of some of their findings to refresh the various subjects that we were dealing with. The first Senate bill that we took up was Senator Reeves' Senate Bill 533, dealing with parimutuel wagering, breakage, and distribution for problem gaming and treatments and support, and creation of the problem in gaming and treatment and support fund. As you know, many of the vehicles that we've dealt with have established this fund. Senator Reeves also dealt with the redistribution of the funding, requiring that 80% be deposited into the problem gambling treatment and support fund, and 20% be deposited in the Racing Benevolence Fund for gambling addiction and substance abuse counseling or recreational education, nutritional, or other related programs. And so, Mr. Chairman, the recommendation of the committee was that there were some still remaining questions in regards to breakage that I think Senator Reeves and some of his witnesses had brought up, which require some further consideration. And the committee recommended we continue the bill to 2021 by a vote of 8-0. And I so move, and I'll yield the floor to Senator Reeves.
Senator Reeves.
Mr. Chairman, one of the individuals that wasn't able to come the other day in the sub is here today, Mr. Ricky Crowder, on the significance of this. And if we could indulge the committee just for a couple minutes as I move to the lectern, if he and Mr. Berman could come up. The subcommittee heard from Mr. Berman, but if we could hear from Mr. Crowder, why this is such an important bill and why it needs to remain alive till we can figure out all the ins and outs of what we're doing with the overall gaming. I think that would be beneficial. So with the committee's indulgence, Mr. Crowder, if you would come up along with Mr. Berman.
Good evening. Thank you for hearing my story. My wife Karen developed a serious gambling addiction, and she ended up taking her life. We met in high school. She was a sophomore, I was a senior. It appeared that everyone in school liked her, the guys, the girls, the faculty. She's just a great gal. We dated in high school and eventually got married. We raised 2 sons. She was a very involved mother with their 2 sons, lives, church, PTA, sports, and many other issues. And then it gets really weird. We ran a business together, and she worked there full time. So basically, we were together 24 hours a day. And for 27 years of marriage, I never knew she had a gambling addiction because we were together forever. She hid it very well, as do all addicts, whether it's drugs, alcohol, or gambling. When I found the money was missing, she panicked, went to a hotel room, and took her life. With her personality, she could not ask family and friends for help. I don't want to see anyone else go through what we went through. I hope you would vote for Senate Bill 533. Thank you for your time.
Thank you, Ricky. Mr. Chairman, based on that testimony and the simplicity of the bill, I know there's some challenges for the racetrack with regard to the breakage part of it. They're perfectly fine with some of the other language, but I think there's been a problem with actually getting funds where they need to go. I would ask that we report the bill, and as the process moves through and we get to a final bill on it, I'd be happy, as I spoke to you, Mr. Chairman, to roll my bill into whatever that is, as long as we have the language in there for the problem gaming and we have a way to fund it.
All right, are there any questions of Senator Reeves?
I have one.
Yes, Senator Evan.
Is that compatible to roll into Senator Lucas's bill? I don't know if there's already a problem gaming fund in there. Does it work with it? No, there is. Thank you.
Mr. Chairman, I would hesitate to roll it in there right now because I don't want to put all our eggs in one basket. That would be my only thing, because if that doesn't go through, we still have the problem and we need to set up the fund and we still need to address these issues.
Mr. Chairman?
Senator McPike.
I'd suggest to the patron that we do have, I think, 2 or 3 vehicles that are currently moving through the body that have the treatment fund set up. And I know it's before Senate Finance as well as House Appropriations to deal with the funding mechanism. I think there's a significant amount of effort to make sure it is fully funded. I think JLARC highlighted in its efforts and reports the underfunding, which has helped to highlight the need for it, especially since we have a number of different vehicles. What I would suggest is, because there's still another question in terms of the breakage questions, that this be continued as a recommendation of the subcommittee to make sure that the breakage question, understanding that the gentleman before I think, spoke eloquently about the need, and I think our need is going to be addressed in a number of different vehicles to take care of this. I think to address I think, powerful testimony that the gentleman provided. I think the secondary question your bill proposes on the breakage, and that is, I think, a question that we don't have enough information to decide today, and therefore to continue it. I think the intent of his bill is going to be addressed in some vehicle, and maybe if you want to add or sign on to a code chief patron on another vehicle, that might be possible.
Mr. Chairman, I don't know if we can separate breakage out from the actual fund. I don't know if Senator Lucas' bill deals with breakage at all. So that would be my concern and why I'd like it to move forward. And if we can possibly do that with the finance bills, I'd be happy to strike the bill at that point if we figure that part out. But I just really worry that if these bills don't go through, for some reason get hung up, we're still in limbo on this thing.
Mr. Chairman,
Senator Donovan.
in light of the fact that this bill needs to be re-referred to finance, if I'm correct, I'd like to move that we recommend and re-refer to finance and let them look at that in the comprehensive body of bills that they currently have.
Mr. Chairman, I would second that because that'll give us some time because we still have to combine a bunch of these bills together. So that would give us a little more time before crossover to kind of see where this washes out.
Mr. Chairman.
Further discussion.
I just want to thank Senator Reeves and both your testimony from the subcommittee, sir, and the gentleman that came today. Thank you for coming forward and bringing your case. I think it's a very important topic, but I will repeat what I said in the subcommittee. My concern is we're talking about $243,000 here. I think Senator Lucas's bill's in the $2.6, $3.4 million range, and I think this is an incredibly important topic, but I don't think this compartment is big enough. But I think you two have sold me on how important this really is, and so that's why I'm going to oppose this measure.
All right. Any further discussion?
Mr. Chairman.
Yes, Senator Bill.
Mr. Chairman, I agree with the words of Senator Mason, and I think this is very important, and I also would like to thank you for bringing this forward, and also for the gentleman for your courage and sharing your story. I know that's very difficult to do, but I really appreciate you doing that. And I think as we go down this path, which I support, of gaming in Virginia, I think we do need to make sure that we adequately handle this part. I appreciate Senator McPike's thoughts on this, but I think even though this will be heard very quickly in finance, I think at least making sure that this is addressed separately is a better choice than bundling it up and perhaps somehow minimizing the importance of this particular topic.
All right. Any further discussion?
Mr. Chairman, I would just say there's discussion of whether or not we're going to include horse racing as part of the overall gambling, and if it does, do they increase their machines to allow more breakage, or are they not? And that's one of the questions, is a policy question that we're going to take up today on this bill. But this bill in and of itself can lie for itself and still be a mechanism if that doesn't work out. If we don't add these guys to the overall gambling big casino bills, then they're going to be separated, and that's a separate issue in the horse racing venue. So I would strongly oppose getting rid of it. Let's send it to finance, give us a little time, let's figure out what we're going to do with the rest of it. And if we need to, I'll melt it into Senator Lucas.
Question of the chairman.
Senator McPike.
When are the gambling bills being heard in finance?
I think tomorrow afternoon at
Tomorrow.
4:30. Yeah.
So, Senator Reeves, there is not time to work out what you're talking about, which is why I suggested that this remain in the body on the question of breakage. I don't disagree with the issues. The issues are important. We are going to take up the problem gaming issues within Senator Lucas and others. But what you risk is if it moves on and then dies in finance, then the question of breakage in the off season isn't before the committee to then study.
Any response, Senator Reeves?
Well, I agree with Senator McPike. That's true. So as long as we can keep it in the rest of the committee, and I'm fine with that.
All right. Well, if that's the case, do you want to have the motion withdrawn then?
I would like to withdraw my second. If Senator Donovan will withdraw the motion, then we'll move to pass it by and the rest of the committee for the year for study.
Substitute motion, pass it by.
All right.
Continue.
Second.
All right, that sounds good. Okay, motion and a second to pass it by for the year. And for Senator Reeves, I'm sure you'll stay involved in the discussions as our bills move forward, but also as the House bills come over. And there'll be plenty of opportunity to try to make sure that we take care of all aspects of things, including the breakage and clearly the issues related to gambling addiction, et cetera.
Thank you, Mr. Chairman.
All right, there's a motion and a second on that to pass it by for the year. All in, vote on the board, so.
Ayes 15, no zero.
Ayes 16, no zero. Thank you very much, Senator Reeves, and we'll look forward to continuing to work with you on it, so. All right.
Thank you, Mr. Chairman.
McPike.
The next bill we took up with Senate Bill 942, and Senator Ruff has requested that the bill be stricken, and I so move.
All right. All right, there's a motion and a second to strike Senate Bill 942. Is there any discussion on that? All right, we vote on the board.
Ayes 15, no zero.
All right, ayes 15, no zero. That Senate Bill 942 is stricken.
Thank you.
Senator McPike.
Thank you, Mr. Chairman. The next group of bills we dealt with were in regards to the casino gaming bills. So we have a recommendation for the committee that we incorporated Senate Bills 102, 374, 609, 743, and 1083 into Senate Bill 36, Senator Lucas's bill, with the recommendation of report. The substitute with and we'll deal with the substitute amendment. They did have a recommendation of 8-0, and we'll begin to address some of the issues and a description of some of the debate and deliberations of the subcommittee as the issues were presented. The substitute that was presented had the 5 locations that were identified in the previous legislation. It set up a slight combination of some of the JLARC recommendations in terms of doing a pre-certification of gaming operators prior to going to referendum. In other words, each locality, if they had a preferred vendor, they would submit it to the state for review for pre-certification and qualifications, reviewing the financial status, ability to operate and support ongoing operations, and the current operations in other states and territories. So the lottery must certify that the preferred vendor meets the standards set out within the legislation. There is a application fee for the pre-certification of $50,000. However, it has a clause of sum sufficient to provide lottery funds with enough resources to do the early review. Additionally, it has a $1 million license fee due upon issuance. Additionally, it specifies conflict of interest provisions rather to various types of gamings in regards to the lottery board. It does set up the problem gaming provisions that we just described in the previous bill, has a voluntary exclusion program. Additionally, has different operators licenses as well as supplier permits under the regulatory scheme for both review and issuance. It does have additional provisions. For instance, it also establishes the Virginia Indigenous Indian Fund. That was a portion of Senator McClellan's bill that was incorporated into the overall substitute. Additionally, it provides a regional improvement commission created consisting of representatives of localities comprise the planning district in which Bristol is located. The referendum question of casino gaming must be held in the 5 localities on the general election this November 3rd of 2020. Richmond will be excluded with a substitute based on the timing of that city's locality as well. The tax rate structure sets up 2-tier system of different tiers between $250 million to $300 million, imposes a 15% tax rate on the first $150 million, between 150 and 300 million, a 20% tax rate, and over 300 million, a 28% tax rate. For the investments of a casino operator over 300 million, it imposes a tax rate of 15% over the first 200 million, over 200 to 400 million, 20%, and then over 400 million, 28% tax rate. There are a number of different provisions that, in terms of the distributions that will be in the bill, as well as 1% to the problem gambling treatment and support fund, and any remaining revenues in the fund shall be appropriated annually as general fund revenues. Mr. Chairman, there is a substitute that incorporates a number of different things, including from the subcommittee's substitute removal of a Section 5 enactment. There are some remaining questions before the committee in terms of minority participation that did come up during discussion of the subcommittee, as well as a provision in the substitute that was before the committee in regards to the competitive language in regards to the city of Richmond. As originally constructed, it limited the selection of the City Council of Richmond to essentially two operators, one which is Pamunkey, the other which was the HHR Rosie's construct. And so there was some level of discussion around whether or not there would be more open competition in the Richmond. That was not resolved in committee, but I did want to bring it up tonight. The lobbyists from Richmond had indicated support. I understand that there was a little bit of change yesterday evening in the House subcommittee dealing with this that said that Richmond did want full competition and not just limited to two. So I believe we'll have some language to deal with that as well, and would certainly open up for discussion. And Amigo, do we have the substitute?
Yes, please distribute the substitute. Sure.
Mr. Chairman, I move the substitute be adopted.
All right, and when we're doing that, do you want to make the motion, include in the motion, rolling in the other five bills, which will be Senate Bill 102 by Senator Pillion, Senate Bill 374 by Senator Lewis, Senate Bill 609 by Senator Norman, Senate Bill 743 by Senator McPike, and Senate Bill 1083 by Senator McClellan. These would all be rolled into, yeah. And so and those will all be rolled into Senate Bill 36, which is Senator Lucas's bill. So any discussion on adoption of this? Okay, we do need to make this a recorded vote because of the rolling in of other bills. So we vote on the board.
That's 13, no zero.
All right, ayes 13, no zero. If you want to be recorded.
Yes, I would like to be recorded for me and Richard, please.
All right, so it'd
I
be.
apologize.
That's all right. So the vote will be 15 in favor and 0 opposed to adopt the substitute with the rolling in of the other five bills. Are there questions that members of the committee have?
So, Mr. Chairman?
Yes.
In explanation, the substitute reflects the subcommittee's actions and recommendations. It provided for both the fix of an enactment clause that distributed additional HHR machines throughout the Commonwealth, as well as it provided a fix and enactment clause in regards to when the referendum could be held in the city of Richmond. And I'll refer to council. Did I cover it appropriately? Okay. Thank you, Mr. Chairman.
What is the timing of the Richmond decision?
Thank you, Mr. Chairman. As the substitute was reviewed by the joint subcommittee, all five of the localities of the cities that were described had to have the referendum by the November 2020 general election. I think the issue that came up was that Richmond may not be able to meet that time frame, so they were taken out, but the other four localities still have to have the vote by that in that time frame.
All right, thank you. And Amigo, what time frame would apply to Richmond? Is there any?
I'm sorry, Mr. Chair, there wouldn't be a time frame that would apply. It would be whenever they were ready to do it at whatever general election that came forward. They just would not have to do it by this coming December.
I don't know, Senator McPike or Amigo, would, in the Richmond situation, if they decide by date X, could they go ahead and do it in November of this year?
Yeah.
So is it nothing
Yes.
to prove with that? Okay, so they basically, what type of advance notice in advance of the November election would they have to give?
Yeah, it's just a matter of getting on the ballot, and I can get that information for you. Do you know what it is? We can find out momentarily.
Okay.
Mr. Chairman, the concern was because Richmond is not yet as far as long as others, that the potential window could close for them to get on the ballot due to the decision time frame necessary to receive proposals, evaluate it, and then move forward with the referendum, because the referendum language requires the locality be named as well as the location. And so by specifying that location, they could miss, frankly, the window. And so we wanted to make sure that there's some flexibility in that regards, and that's the subcommittee's recommendation.
So Senator McPike, if they do not get on the ballot in Richmond in November of this year, would they then fall back to November of next year as to when they would be eligible to get on the ballot?
Yep.
So it's specific to a general election. So.
That's right, Mr. Chairman. Otherwise, Richmond's opportunity would be foregone, as written in the original substitute. So this helps to deal with that condition.
All right. Are there further questions of the patron or of the subcommittee chair?
Mr. Chairman?
All right.
The other, I think, pending issue before the committee took testimony on whether the Richmond area would be competitive in a competitive market, and I would ask if there's a City of Richmond representative to speak more clearly maybe to the full committee than my understanding was reported to our subcommittee.
Mr. Chairman, Ron Jordan, representing the City of Richmond. When you heard the bill yesterday, the council had discussed the issue the night before and had not seen the substitute. So the information provided yesterday was incomplete. The city would prefer have an open competition.
Okay. Thank you, Mr. Chairman.
All right.
The language to deal with that, I do have a line amendment prepared.
All right.
If staff can help to distribute that as well, we would be able to resolve this and ensure some level of more open competition for Richmond versus sort of having it narrowed down to just two parties in a shall condition. The second part of the line amendment also addresses one of the comments that I think the subcommittee was considerably concerned about, is the substitute as originally presented did not have inclusion for minority participation. And so the language as defined on the second line amendment would ensure that a percentage of ownership in the proposal by minority-owned businesses defined in this section would be a part of the consideration of evaluation as a part of the full package. And I so move the amendments in a block.
All right, we have the amendments in a block. Question for staff. The first amendment, number 1, it says it's page 1 of the substitute in line 1245. I assume you mean it was page 47? Is that what?
Embarrassingly, yes, Mr. Chairman.
If you'd fit 1,245 lines on one page, I would be impressed. So. All right, so we'll make that correction there. It's the line, page 47 on the first amendment there.
So, Mr. Chairman, I have a question.
Right. Excuse me?
I have a question.
Yes.
Pertaining to the amendment, so nothing in these amendments would preclude the previously two named, the Pamunkeys or Colonial Downs, from competing in the open competitively bidding process. Is that true?
Right.
Yes, Mr. Chairman, yes. What Amendment 1 and 3 do is they take those two parties from being required proposers or proposals that the city would have to deal with and moves them to be given substantial preference or so they would be competing but have I don't want to say an absolute preference, but they would be given, as the language says, some consideration.
Mr. Chairman.
Yes, Senator Bell.
I would ask Senator McPike, and I'm a little concerned, I'm going to propose amendment, but I wanted to ask about this. The language on the amendment, which at the end of the first line says substantial and preferred consideration. I almost feel like that might be a little bit too far. I would feel better if we took out substantial and just left it at preferred consideration.
You consider that a friendly amendment unless Amigo has another.
That language was taken from from what was in the substitute before this amendment dealing with the Norfolk process. That is the use of those two terms, substantial and preferred. So I tracked that language in the amendment.
Question for Mr. Chairman.
Okay, Senator McPike.
Does it cause any harm? It still has preference to go to Senator Bell's question of just simply removing substantial and. It still provides a preference.
No, it doesn't cause any harm, not in my view.
Chairman, then so move that.
So the
Sorry,
motion is on the third amendment at the end of the first sentence to strike substantial and.
Yes, Mr. Chairman, that's correct.
They shall provide preferred consideration, but not substantial.
I second that.
All right. The motion is made and seconded to strike substantial and those two words from the first line of the amendment number 3. Any discussion or questions on that? All in favor say aye.
Aye.
All opposed, no. All right, that amendment is to the substitute is adopted. Are there further questions at this point? I didn't get it either, but so.
So, Mr. Chairman, I know the patron has been waiting patiently,
yes,
as well as the support with Mr. Johnson, and so the patron has been, I think, great to work with to find out a blend between some of what the localities have been pursuing, as well as what some of the JLARC recommendations through this process. And I know the 20 years in waiting, and would like to certainly invite her to share some words.
Senator Lucas.
20 years and 4 hours.
Mr. Chairman and members of committee, I don't have words to describe to you how I'm feeling right now, because after waiting so long to get to this point, I feel like I'm almost levitating. But as I said to you, my passion for casinos started in the early 90s when I worked on the Riverboat Gaming Bill, and I see there are several other people here who worked on them at the same time, and their hair, ironically, has turned the same color as mine. So I think may have had something to do with working on the casino bills, or maybe it was just the time that we've been here. But I just want to say to you that when I started working on the casino bills, as you all know, it was to try to help my hometown, the city of Portsmouth, a very depressed city. And as we, over the last 3 or 4 years, shall I say, we managed to align ourselves with 4 other localities that were struggling, had some of the same kind of issues that we have been suffering in the city of Portsmouth for years. This bill passing for the 5 of these localities would be like our Amazon. It would give us an opportunity to determine our own destiny. We're not asking for a handout from the city of Richmond or from the Commonwealth of Virginia. We're only asking for an opportunity to improve our own economic development in our localities. And we see this bill as a way of getting there. And I could just not say to you how grateful I am, even though it's taken 20 years, 30 pounds, and gray hair to get here, how happy I am to finally get to this point. And so with that, I'd like to invite my wingman, and I'd also like to thank. I want to say this publicly. A lot of people think that Senator Norman and I don't get along. We actually get along famously, and he has been extremely helpful to me throughout this process. So I just needed to be able to say that. I need to thank Senator Jennifer McClellan, Senator Pillion, Senator McPike. I mean, there's so many people that I just need to thank. As I turn to the audience and just look at all of these people have been so helpful. This was truly a team effort. My mayor from the city of Portsmouth, the management team. Yeah, oh, absolutely. Senator Linwood Lewis, and he's not here right now. Could I just ask all of the management team from the 5 localities who are here to stand, because they've come down to Richmond every day this week almost to try to see that this bill got ushered through and offer whatever assistance they can. And so I'd like to just have them stand. Bristol, Danville, Portsmouth, Richmond City, I'm sure, is here. Norfolk, we have people representing Norfolk. And I just want to thank all of them, because it took this entire team to help make this happen. And so I'm eternally grateful to you. I don't know how much longer I'm going to be in the General Assembly, but I promised I would never retire until I got this bill passed. So I know I'm here for 4 years, and unless I get another pastor, like the lady said when she came up earlier, she said what her pastime is. My pastime for over the last 20 years has been casinos. And so with that, Scott, would you please come and help me out?
Good afternoon, Mr. Chairman. I'm Scott Johnson. I represent Bristol Regional Casinos and Resorts. I want to add 2 more thank yous, and the folks at the table in front of me work mighty hard, and Amigo and Ms. Benz and others, so thank them. Senator McPike and Senator Barker, I can do whatever you want. I'm mindful of the hour. If you want me to take questions, I'm glad to do that. If you want me to point you and walk you through the substitute, I'm at your mercy.
All right. Are there questions of Senator Lucas or the illustrious counsel for Senator Lucas? So,
Second.
All right. We have a motion to report the bill as amended. And,
And re-refer to.
And re-refer to finance. Yes, and re-refer to finance.
Mr. Chairman, I think Senator McPike has got some line amendments to the substitute that Mr. Williams got.
Additional one.
Yeah, thank you, Mr. Johnson. So there's also one consideration that in discussion with the Virginia Lottery, the time frame to return the evaluation was of concern. We had a few of those questions. I think the initial substitute had 60 days.
Yes, sir.
The new line amendment would extend that to 9 months with a request for a 30-day extension built into that. And if council can help with that line amendment.
So, Mr. Chairman, just curious, 9 months? What?
So, Mr. Chairman, this is for the licensure phase, not the pre-qualification phase. So the licensure phase is really the full deep dive. They've got a referendum in place. They're moving forward with basically the full evaluation, probably concurrently zoning approvals with the locality. And at the end of that, they've got to pay that $1 million with the licensure fee. So it is a substantial deep dive prior to the licensure to ensure that the operators have been fully vetted before that issuance takes place.
Sir, Mr. Chairman, I would just add, too, that we have been in great communication with the Lottery Board and working with them. And it sounds like a long time, but in other states, it may be 6 months, it may be a year. We're trying to hit a reasonable target. Everybody wants to do it right. We want the lottery to do it right. We want the operators to do it right. And you're correct. That process includes background check, financial checks, the real thorough deep dive. And we've got some other things along the way we'll be working with the Lottery Board on, but it's been very collaborative to make sure that this is a success.
Mr. Chairman.
Senator Mason.
So thank you, Mr. Chairman. In the subcommittee, I asked you repeatedly about a rigorous process at this phase. This is the phase we're talking about, right?
That is correct.
Thank you, sir.
Mr. Chairman, I saw some pop-ups over there. Is there anybody that wants to comment on that?
Excuse me?
I saw some pop-ups when we brought up the timetable. Is anybody want to comment on that, or? Okay.
I think they're saying they're good.
If I could just briefly.
Yes. Former Senator Wagner. So.
now Deputy Director of the Lottery.
That's right.
And I want to thank
And you
Scott
figure that's a
and
promotion,
the
so.
patrons. We just had a first opportunity to look at this bill yesterday when it passed out of subcommittee, and there's a number of other tweaks and some financial stuff that we'll be bringing up to the Finance Committee tomorrow in terms of making sure we have the resources and the tools necessary to properly regulate it and properly vet it, Senator Mason, as you brought up. This is a much more extensive process than I was even aware of, based on the definition and the direction we got from the bill that was passed last year. We've been checking other states and how they do it and how they manage it, and the vetting process is quite thorough, I can assure you, up to and including going to check every 5% owner and above, right on down to going to visit their home state to ensure that we have a casino operation that can make us all proud and ensure that we keep the criminal elements away from any part of that. It's a very extensive investigation, Mr. Chairman, and we're hopeful that 9 months plus an extension will be significant. We do recognize that you all will be back here next year, as we will be, so if we find there's some glitches, we may ask for adjustments to that. But certainly in terms of doing it, to give you an idea, Maryland regulates 5 casinos is what Virginia's looking at, and it requires somewhere around 115, 120 employees to do that. And so that's the kind of standing up operation, and we would anticipate not 1 application, but 5 applications coming in relatively quick order. So it's a tall order, but we are prepared to put the emergency regs in to do everything we can to support referendums in all the localities this November and continue the regulatory process of putting regulations into place while preparing to do this. So it is a tall order, but the lottery stands ready to do it. We've done some prep work in the past and look forward to getting the rest of our concerns written into legislation as it moves through the process, Mr. Chairman.
Mr. Chairman.
Thank you, Senator Donovan.
That was just my follow-up. I fully cognizant that we've been working on this for a couple of years and we're all anxious to get going. I want to make sure whatever Virginia builds is safe and it is well vetted. And I just want to make sure, since we're starting from scratch, 9 months sounded aggressive to me. Optimistic, maybe?
We'll be back here next year, so.
So, Mr. Chairman, to put the bill in proper order, I'd move the line amendment be adopted.
All right.
The two.
Two additional line amendments. All right. So those 2 would be added to the 3 we had previously in terms of line amendments. Is there any discussion on those or questions? All in favor say aye. Aye. All opposed, no. Those line amendments are adopted. So we have 5 line amendments now to move forward to the substitute to move forward.
So,
all right, we have a motion to report the substitute as amended with the 5 line amendments and to re-refer to Finance Committee, which will take this up tomorrow afternoon. Yeah, so, and that includes rolling in the 5 bills that we did at the beginning there. So, any further discussion? All right, if not, then we will vote on the board.
Ayes 13, no 0, abstentions 1.
All right, ayes 13, no 0, abstention 1. Senator Lucas, you're on your
Mr. Chairman,
right.
members of the committee, on behalf of the 5 cities listed in this bill, we say thank you.
Thank you.
Mr. Chairman, that completes the gaming subcommittee report.
Thank you very much, and Senator McPike and all the members of the subcommittee, I thank you for everything you did. We do have action on one other bill, Senator Vogel.
Thank you, Mr. Chair. I have Senate Bill 627, and we've had a lot of discussion and debate over the bill, and we are, I'm going to respectfully request that we carry the bill over. It's a bill that I was bringing, yes, at the request of a number of contractors who desperately need some help, but we are not going to be able to resolve it before the end of session. So with that, I ask that the bill be carried over, and we're going to work on it in the intervening time.
All right. We
that
have
would make
a
you
motion
happy.
and a second to carry over Senate Bill 627. Any discussion on that? All right, we vote on the board. Open the vote. Yes. All
Ayes
right.
14, no 0.
14 ayes, no, 0 nays. That bill is carried over. And with that, we rise.